Friends, in this episode I would like to discuss about Article 21A of Constitution of India. We know that Article 21A was not originally inserted in Constitution, but it was inserted as an effect of 86th Amendment in the year 2002. So Constitution, by virtue of 86th Amendment in the year 2002, this new article, that is Article 21A, that is right to education as a fundamental right, was inserted in our Constitution of India, and that is the topic of discussion today. By virtue of Article 21A of Constitution of India, the duty on the part of the state to provide free and compulsory education to all children from the age of 6 to 14 years. So what is the effect of 86th Amendment in the year 2002? That Article 21 was inserted, which provides about the right to education and free and compulsory education. So these two words are very important. Education should be freely provided and it must be compulsory. So what is written etymologically, it means that it must be provided to all children in our country, free and compulsory education from the age of 6 to 14 years. But friends, how much it is implemented, or whether all children are getting that education or not, or what is the effect or utility of that education, that is another aspect what I am discussing later on. But etymologically it is written there that compulsory education must be provided. That is the effect of 86th Amendment, and not only that, as an effect, there Article 45, it is the fundamental right, Article 21A we know, and as a result of it, Article 45, which is a directive principle, that is substituted. So let me consider what is Article 45 right now as a consequential effect of 86th Amendment, and what was the earlier position. That means now I wish to compare between the old provision of Article 45 and what is the substitution. Let us have a look. Friends, as per old Article 45 of Constitution of India, it was the provision that compulsory and free education must be provided by state to all children within a span of 10 years from the commencement of the Constitution. And after the amendment, that is 86th Amendment in the year 2002, now it is emphasizing that state shall endeavor to provide early childhood care and education till the completion of 6 years of age. That means Article 45 earlier position was that free and compulsory education for children within 10 years, free and compulsory education must be provided by the state for all children. It is very important that it is written for all children till 14 years of age. And another, after amendment, that means after substitution in the year 2002, that provision for early childhood care and education for all children, it is written over there, till 6 years of age. And we know very well that fundamental right, it is actually following for achievement of the objectives as enshrined in our directive principles. So what is the result? That by virtue of the insertion of the new article, that is 21A, consequential effect 45 was also amended. So that is the short history of introduction of Article 21A. Now I would like to discuss about some cases which actually caused the change. That means as an effect of those judgments, this amendment was made, and so Article 21A was finally inserted in the Constitution. I would like to discuss about two landmark judgments in this regard. First is Mohini Jain versus State of Karnataka. in this case the question came for consideration before our apex court that whether right to education should be considered as constitutional right. Now court said that right to educational obviously is to be considered as a constitutional right, but that point was not considered by the court, that whether the right to education will be considered as a fundamental right or whether it will be considered as a right to life as inserted in our Article 21. That means whether right to education should be considered as a right to life as mentioned in Article 21, that was not considered in this case. Later on, another landmark judgment as an effect of which ultimately 86th amendment was made, and in the year 2002 Article 21A was inserted in Constitution, that is Unnikrishnan versus State of Andhra Pradesh. In Unnikrishnan versus State of Andhra Pradesh, various issues raised before the court of law, before our apex court for consideration, and one of that issue was that whether right to education should be considered as a fundamental right or whether right to life as mentioned in Article 21 will include the right to education. Supreme Court stated that right to education should be obviously considered as fundamental right and it must be considered as a right to life, because without education life cannot be secured. So right to life obviously must include the right to education. So as a result, by virtue of 86th amendment in the year 2002, right to education was inserted in our Constitution of India. But the question is whether after the insertion of it in our Constitution, in the year 2002 it was inserted, our Constitution came into effect in the year 1950. We know that fundamental right, what is there, it must accomplish the objectives enshrined in our directive principles of the state policy. Moreover, in Unnikrishnan judgments, Supreme Court observed that fundamental rights and directive principles are supplementary and complementary of each other. Fundamental rights must be followed in such a manner so that the objectives enshrined in the directive principles are satisfied. But how much it is accomplished, that is the question can be raised in this present scenario, because we know that Swami Vivekananda states that we want that education by which character is formed, strength of mind is expanded, and ultimately by which one man can stand on his own feet. So whether we are getting that education, because there are so many children in our country are lacking their food or nutrition. So without food, nutrition, without the proper treatment, how they can survive? Then the question of education comes. Whereas our Article 21, 21A or 45, whatever may be, all are emphasizing upon free and compulsory education. But even after independence, they are getting some education, only they can sign by somehow. But we know that giving the sign or making the sum total, it is not the proper criteria or proper education as stated by Swami Vivekananda. So that's why how much they are educated, that is the main question of fact, because we know that one educated person is only fit to select their representative who are being sent to parliament or assembly. So if the people remain uneducated, so whatever they are selecting, whether it is right, so unless the voters are educated properly, how they can select the proper representative who are actually building up our nation? That is a crucial question can be raised in this occasion. So that's why what it can be said that even after the achieving independence, though these are enshrined, so our state has realized, Supreme Court has realized that yes, education is very much crucial thing, and that's why it has now been at least etymologically inserted in our Constitution as a fundamental right. But we know as per the present situation, only proper education are getting by few elite class of the people, and by virtue of means where they are admitted for English medium school or various means costly professional courses, others are too much eager to study, but for lack of their family support or their monetary crisis, they are not getting any chance. Only a few persons who are by their effort or by some occasion for support of fortune, they are getting the opportunity for higher educations. They are focused as an instance, but for the other 90% remains the uneducated. They are not getting the proper food, proper medical treatment, and we know how much the privatizations of the school and colleges, how much expenditures are enhanced for the education, books, other things like laptop, mobile, etc. all are sine qua non, most indispensable things in the present scenario for the proper education. So they are not getting their food properly, how they can afford the mobile or laptop or something apparatus which are very much essential for the true and proper education. Signing the paper is not the sign of the proper education. So that must be considered by the present scenario by the state, because only the persons who have money in the pocket, they can admit their child for a very good school or colleges, and where the fees are too much enhanced, which cannot be afforded by the ordinary people. So how the Article 21A objective and our constitution stated about equality, how will be maintained in the state present scenario? That is the question, and that is to be very seriously considered by the court of law and judiciary.